Everybody wants financial security in retirement, and there's ways to ensure you can have it. Things like making sure you have a well-diversified portfolio, making sure you have proper insurance in place to cover yourself in the event of litigation or a worst-case scenario. But the one often overlooked area is estate planning. And today what I want to dive into are some essentials around estate planning for your financial security. Keep it right here. Good day, everybody. Chris Herline here of REAP Financial, host of Wealth Radio on News Radio KLBJ every Saturday, and host of Retire Ready TV on KXAN every Wednesday throughout the week, where I drop new content there. I want to make sure you subscribe to our channel here and hit the bell for notifications. I drop new content on this channel every Wednesday for you so you can stay on top of the latest. Today, what I want to do is talk about estate planning essentials so that you can have true financial security. And stay tuned through the end today, because a lot of people get this wrong and it can cost you big. So let's dive in. When it comes to estate planning essentials, we'll start with the basics. Make sure you have a will. Make sure you have powers of attorney. Make sure you have HIPAA documents. When it comes to basic estate planning, these three areas are the ones we want to see. This is Estate 101. Wills, power of attorneys, advance directives, your HIPAA documents, okay? The thing that a lot of people don't understand is that if your spouse has an IRA, has a 401k, and they get incapacitated, in some cases you lose a spouse, I'm going to tell you something. We've got horror stories about not being able to service or help a family member administer an account without that power of attorney. Wills, power of attorneys, these type of things generally are done when you're younger. Maybe you have kids, you're getting ready to go on a trip, and you got to do that responsible thing, and you haven't looked or touched that thing in 20 or 30 years. Well, things have changed. You may be new additions to the family. Your wishes may have changed. You may have moved states, whatever it is. You got to make sure that you have these documents in place, make sure that they're updated, and make sure that if you're going to be leaving wealth to your heirs, it's done so in a way that it's protecting them and you're protecting your wishes. If you have one, ask yourself, when is the last time it was updated? Now, as your wealth grows through the years, another essential may be to establish a trust. There's a lot of different types of trust. The one we see most retirees put in place is what's called a living revocable trust. This is tied to you or you and your spouse's social security number. It's a living trust, so you're not having to do an annual tax return with it. And the living trust typically is going to serve as the beneficiary of your assets. So if you're married and you and your spouse had a living trust, what that may look like is that you and your spouse are primary beneficiaries on each other's accounts, but if something happened to you both, or when both of you pass down the road, the trust is the beneficiary, not your minor children or grandchildren, okay? The trust gives you control of the money when you're 6 feet under, okay? It can allow you to really arrange your assets in a way that they can go to different things legally. They cannot be changed. And I'll give you an example of this. You may have a couple $1 million portfolio and you say, I want to take 300,000 of that and make sure that that funds the next generation of college funds, or ensuring that my grandchildren are going to get this amount, or making sure that my son that's really responsible with money, he's going to get his inheritance when I pass. The other son that's maybe not as good as money, he's going to get his inheritance over maybe a 10-year period so he can't go spend it all in 1 year. So it gives you control. It also can help you with privacy. Privacy is very important for our affluent clients. And when you have money that's left to a trust, your money that's left to trust, in most cases, the assets that's left in trust, can go around probate. Doesn't get stuck in the courts, doesn't get tied up for months on end. So it can really pass your assets, your wealth with ease to your heirs. So establishing a trust can benefit you from a control standpoint. It can benefit your heirs from a standpoint of just being able to access that money pretty much day one without the courts and probate getting involved. So there's a number of trusts out there. We see revocable trust. We see irrevocable trust. Consult with an estate attorney, or we can connect you with one of our vetted professionals to discover if a trust makes sense for you. One more thing on the trust, and this is a really common thing that we see, is you get through the process with your estate attorney, you get the documents drawn up, they're witnessed, they're notarized, and then you don't fund your trust. You don't go in, you don't change the beneficiaries of your accounts to the trust. You don't maybe think to put the deed of your home in the trust or your cars in the trust. Any asset like that I'm mentioning can be left to the trust and then go around probate. So if you're gonna go the trouble, the expense to establish this, make sure that you fund the trust, make the adjustments after the fact. Now, if you have minor children or you're wanting to leave money to minor grandchildren, always keep in mind that you cannot leave money to minor children. They won't be able to inherit it. It can be a mess. It can get tied up in the courts. In many cases, you may have to go before the court year after year. So, if you've got minor beneficiaries, a trust is likely a good idea. But as I mentioned, consult with an estate attorney. And be sure to leave your questions around this topic or any others in the comments section, and I'll try to address that in future videos. Now, let's keep talking about this area. When it comes to essential estate planning, be sure that you and your spouse are clear on your beneficiaries. Who are you leaving money to? Why are you leaving it to them? For what purposes? Is this person that you're leaving money to going to share the same values of saving and spending that maybe you have or you would like to see? I encourage families to maybe gift money throughout the years. Help them along the way. You can participate not only in the joy of the gift and seeing it help them through maybe their younger years or even your grandchildren, but it also allows you to see what kind of steward they are with the money, right? And this can help dictate how much you're leaving and who you're leaving it to. You may also want to consider causes you believe in. If you give money charitably or planning on leave money charity, what dollars are you going to leave? That needs to be dictated in your wills and trusts. Because if you leave your IRAs and 401ks to your kids, typically that's going to be 100% taxable to them. If you leave your IRAs and 401ks to a qualified charity or 501c3, entire amount goes to those causes you believe in, tax-free. So there's some strategy that needs to be written in around what kind of dollars you're going to leave. Okay. Now, the thing is, the reason we see a lot of times that these things are outdated or they haven't been done at all is no one wants to have these conversations, right? Nobody wants to talk about dying, or they think I'll get to it down the road and then 20 years has passed and you still haven't updated things, right? You need to also be thinking about your parents that are maybe in their 70s, their 80s, their 90s. When was the last time you had a conversation with them about how they have their estate set up? Because chances are you may be an inheritor, you may be an executor or a trustee, and I'm going to tell you, it's a full-time job. It's a lot of work to get the estate settled in many cases. You need to be prepared for that. Doesn't mean you need to know what you're going to get. Doesn't mean you have to tell your kids what your net worth is or how much you're going to leave them. But the more open communication you can have around these issues, typically we're going to see a better plan around that. So the thing is that if this is hitting a chord with you, you may want to schedule a time to review and update your estate plan. And this is one of the first things we can do for you. We can run an analysis on your current estate plan. Are there gaps that need to be filled? Maybe everything's buttoned up, but at least you know. You want to also take a look at listing important life changes that would make it necessary to adjust these things. I mean, you think about it, you may have a son or a daughter that's had a couple kids since you put your thing in place. Do you want to make sure the grandkids are in that? Were you divorced? Did you have a son or daughter that's divorced? That can change the inheritance and beneficiary designation as well. So just think about important life changes that may make it necessary for you to make changes on your estate plan. And then also we just need to keep in mind that there could be legislative changes coming out of DC that can dictate or mean that you may need to amend some things throughout the years. So typically we like to see you have an analysis done on your estate work generally every about 5 years is sensible enough. Okay, so I'm gonna get into more detail about legacy planning in this next video. Click here to watch.